Thank you. Welcome to all my colleagues. It was a long day, but I thought a productive day. Severability. Can you tell me again, I know you've been asked 100 times, the doctrine of severability, what does it mean?
So the doctrine of severability is a doctrine essentially of statutory interpretation. And what it means is if you have a statute, and the Affordable Care Act is obviously a very long statute, if there's one provision within the statute that's unconstitutional, the question is whether that one section can simply be rendered null and excised from the statute, severed, so that the rest of the law stands, or whether that provision is so central to the statute that its unconstitutionality, like once it's pulled out, the whole house of cards collapses. And the presumption is always in favor of severability. It's a question of your intent.
Do you agree with Justice Scalia's assertion that the Voting Rights Act is a, quote, perpetuation of racial entitlement, end quote?
Senator Feinstein, I don't obviously know what Justice Scalia was thinking when he said that. And any characterization of the Voting Rights Act or a statement like that is simply really not something I can opine on because, you know, that's tied in, I would think, with these Shelby County questions.
Well, can you opine? I'm not asking for a formal opinion, but would you believe that it's a perpetuation of racial entitlement?
Well, Senator Feinstein, I think that goes to the question of whether the coverage formula was outdated and needed to be updated from the 1960s or not. I take that to be the thrust of the disagreement in Shelby County and the position that Justice Scalia was taking. So again, I can't express a view on Shelby County and whether the majority or dissent had the better of the argument.
So here's what it boils down to. After Heller, after the decision, after Scalia's statement, you concluded that any felony can take away your right to vote, but only a violent felony can take away your right to purchase an AK-47. Why?
Senator, with respect, that's distorting my position. What I said in that case, which is what Heller said and which is conventional in all discussions of this, to my knowledge, is that the right to vote is fundamental. However, it is an individual fundamental right that we possess, but we possess it as part of our civic responsibility for the common good. The same thing is true, for example, of jury service. Whereas individual rights, and this is again a distinction that's drawn in case law, individual rights benefit more the individual. And the entire dispute in Heller was that the majority thought that the Second Amendment was an individual right, and the dissent thought it was one that was a civic right, that was a right that people possessed, but they possessed for the benefit of society by participation in the militia. And it is a distortion of the case to say that I ever said that voting is a second-class right. That's simply not what that passage means.
The very terms of the civic rights argument, then, the right to arms would have been treated differently than rights like the right to vote. And let's get down to the bottom line here. Heller did establish the individual right. When you finished with your dissent, here's what it came down to say. If you are guilty of a felony that is not violent, you can lose your right to vote, but you can't lose your right to buy a gun. Am I wrong?
Senator Cantor had nothing to do with the right to vote. The point that I was making in that passage, the 14th Amendment actually expressly allows for states to deprive felons of the right to vote. And my point was that there was no similar language in the Second Amendment. I don't have an opinion and have never expressed one about the scope of a legislature's authority to take away felon voting rights. What I said is that there was a history of such provisions in state constitutions and in the federal constitution, but I did not intend, and if my words communicated that, it was a miscommunication. I have never denigrated the right to vote.
I think it was, at best, a serious miscommunication.
I have never been more proud of a nominee than I am of you. You've been candid to this body about who you are, what you believe. You've been reassuring in your disposition, and this is history being made, folks. This is the first time in American history that we've nominated a woman who's unashamedly pro-life and embraces her faith without apology and she's going to the court.
It is striking that as we sit here right now in this committee room, there are only 2 Democratic senators in the room. If you look at the dais, there's chair after chair after chair that is empty. The Democratic senators are no longer even attending. I assume they'll show up for their time. But it is indicative of what they're tacitly admitting, which is that they don't have substantive criticisms.
Mr. Chairman, may I make a point of personal privilege?
Of course.
We're in
Yes,
the
you may.
midst of a COVID-19 crisis, a pandemic, and some members are in their offices following this on television, and to suggest their absence here means they're not following or participating is incorrect.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.